G'day everyone. Now firstly, with this particular video I will put a note for the e-safety commissioner if there is an attempt to illegitimately get rid of this video, if complaining to the likes of Facebook and YouTube are ineffective, which I suggest they should be ineffective, then this is a legitimate video with legitimate news about legitimate issues, and it involves political candidates and reasoning and some illegitimate behaviour of someone in particular who is associated with a couple of different interlinking groups. Now I do suggest that it would be illegitimate to remove this video, but I know that the person who this video is mainly about has gotten things removed before. So the video is about Anna Marie Frances Stancombe, and she's associated with certain groups. Got some interesting bird calls here. And as an example of a legitimate video that she had removed, then she was falsely claiming that I had assaulted her, that I have been charged with assaulting her, which neither of those things are true. I've never assaulted Ms. Stancombe. She also claims that another person assaulted her on my behalf. Again, that is false. And to counteract that in the information war, then I posted her bench charge sheet where she was charged with having unlawfully assaulted me, and also her false claims to having a restraining order against me. Again, I posted my successful restraining order. In Queensland they're called peace and good behaviour orders, because it's not a domestic violence order, which is another type of restraining order. But I posted my successful restraining order against her, a court document, and they got removed by the e-safety commissioner apparently. So anyway, as I just said, I do have a successful restraining order against Ms. Stancombe that is still in force, and I presume it will be extended when we have yet again court for that, because Ms. Stancombe is trying to appeal the successful restraining order application. And anyway, so perhaps I can get that extended so it's not just for 1 year, and get specific conditions put on there that aren't currently on there, with Ms. Stancombe harassing me and defaming me non-stop with multiple Facebook accounts, with proof of them actually being hers, which I'll release in good time. But anyway, so she then put in a false, vexatious, perjurious, fraudulent peace and good behaviour order application against me, and that was after I got after I put my application in against her, but not before I actually was awarded that, because she kept dragging things out. And anyway, basically her one was then thrown out, her application, because she didn't turn up to court. She then perjured herself, claiming to the court that she had a different court matter, let's just call it that, at the same date. So that's why she didn't turn up without even telling the court. And I happen to be subscribed to all of the court's lists, and also then had to pay money for a special court record check facility or tool that exists. And she lied, but she successfully got the matter reopened based on that. I think that was one of my videos that the E-Safety Commissioner took down, was after I successfully got a peace and good behaviour order against Ms Stancombe, and then left the courthouse at Southport and was discussing that again to counteract the defamatory content that Ms Stancombe should be in jail for. Either as criminal defamation or using carriage service to harass, menace or cause offence, or there's even death threats that I get from some of these accounts. So, using carriage service to threaten to kill, and then really it should have in brackets or cause serious harm, because if you look at the actual charge itself, it does also mention that as well. Anyway, and that's also not even talking yet about the perjury that Ms Stancombe has done continuously, and when I get the transcripts, the police will be getting those and hopefully lay charges on her. But with the reopened, and what reopening is she lost her application in the first place, and then a reopening is let's pretend she didn't lose and we'll do it as if she didn't lose, and then redo the case basically from scratch, or whatever stage you're up to. So that was done. We then had 3 full hearing days. The first day there was a couple of hours off due to Ms Stancombe and myself being non-vaccinated and unable to wear masks, that kind of thing. I don't know what Ms Stancombe's reasons are, but I have various reasons why I have mask exemptions, and basically I don't need to discuss those reasons, but just so you're aware. But that delayed proceedings on the 1st of February 2022 by a couple of hours, because the court had to work out what to do, that kind of thing. Anyway, so that was day 1 of the hearings, one of the highlights of which was Ms Stancombe admitting to a Sue Paul fake Facebook account, which in later days of the hearing she then claimed that she didn't admit that, but again I'm waiting for the transcripts. And then there were some other interesting happenings, and the next hearing date I think was when was that? The 10th of March maybe, and that again was quite interesting. And then there was another full hearing date around the 24th or 26th of March, and there's finally been a decision made. I do say finally, but obviously the magistrate wanted to be very thorough and was very thorough, and considering all sides of the argument, and then the decision was pronounced on the 1st of April. One funny thing would have been if it was before midday, and then Miss Stancombe could try and claim, I imagine, that it was an April Fool's Day trick or something like that. But it was, probably about 3 o'clock or something like that when I got a phone call. We both had permission to appear via telephone since it was only the decision, and let's just say I won absolutely and had costs awarded against Ms Stancombe, so she owes me money. And basically I'll go back a little bit. So when applying for a peace and good behaviour order, i.e. a restraining order in a non-domestic relationship, there have been rumours that Ms Stancombe's my ex, which is not true. I've never been romantically involved or interested in Ms Stancombe, as anyone with half a brain could probably a deuce or whatever. Despite Ms. Stancombe's false claims that I supposedly asked her out some Valentine's Day, she wouldn't say how, didn't have any proof of that, because it never happened. But that was one of the interesting lies that she made, and she's made videos to, other people claiming that, and it's just false. But then people contact me saying, oh, you were married to her for years and have kids with her, why don't you just drop it, sort of thing, which I never was married to her, never had any physical contact with Miss Stancombe besides the 2 times that she assaulted me, and that was her contacting me, not the other way around. And anyway, it's just like Ms. Stancombe lies to claim that on the 30th of May 2020, which was my first really big protest that I had, I'll just get that ant off me, that she claims, despite that I was live streaming everything, that I gave her my phone number, in which case I did not. She gave me her phone number via Messenger, and I never called it, and nor had any intention of calling it. And it's interesting how many lies someone can actually have fall out of their mouth. And I've never known anyone, or can't think of anyone, that has been so dishonest, and luckily the judge has seen past that. So some of the other... sorry, I've got to work out what I'm leaving out of this video, because otherwise someone can try and claim that it is causing them offence, i.e. Ms. Stancombe. But I will talk about how to get a restraining order, limited to peace and good behaviour order, and then say what Ms. Stancombe claimed, and then maybe cover some of the highlights of the case after that. So, to get a peace and good behaviour order, you first apply for it. You get a document, you can print it from the Queensland court's websites, or just go into a courthouse and grab one, and basically you have to show certain things. So the main thrust of it is show that there was a threat, and it can be more than one threat. You can have more than one ground to get the restraining order, but there has to be a threat to assault or cause bodily injury to someone under their care, or to damage or destroy their property, or then there's sort of a catch-all part, which is or conduct that could amount to such things. So a threat might be, someone says, I'm going to break your legs, as an example, so that's causing bodily injury, and it's also assault. And then there is, sorry, I'm getting a phone call at the moment, but it'll go away. But then there's like the conduct. So someone might not actually say that or gesture that they're going to punch them in the face or whatever. It doesn't have to be by words, it doesn't have to be direct. It could be I'd hate for someone to, I'd hate for you to fall down the stairs, wink, something like that, because that still tantamount to a threat, even if it's indirect. But if there is a pattern of negative behaviour that suggests that a person may be dangerous to the person, they're, people they under them, i.e. if they're a carer, the disabled person they're looking for, or looking after I should say, or their children or something like that, or threats to their property, indirect, so it can be even like super indirect. So someone, just say someone's car got scratched or whatever, then someone could write a little note and put it on their windshield, and even if they didn't actually scratch a car, but they might write a note saying, haha, serves yourself right for parking in the wrong spot in the driveway or something like that, if it's a apartment or battle axe property, dual occupancy, or whatever, in which case that can be conduct that could be conducive to a threat to property, because even if it was known 100% that the person didn't do that conduct in actually damaging the property, then it may be suggested that if the person did park incorrectly according to that person, that they might do it now. But anyway, so then you put that into a Justice of the Peace or a Commissioner of Declarations, which is like not as qualified as a Justice of the Peace. So Justices of the Peace can actually act as magistrates in Queensland and, tribunals as an adjudicator, that kind of thing. But a Commissioner of Declarations is basically, if you need to prove your identity or get a document witness, an affidavit as an example, then they can sign that. And in Queensland, it's sort of a bit weird compared to New South Wales, in that in New South Wales you can get a document signed by a pharmacist or a police officer or this person, that person. There's a whole bunch of different categories. A religious leader, doctor, nurse, etc. They can witness documents without being a JP or a equivalent of a Commissioner of Declarations. But in Queensland, you can't do that. You still have some occupations that can do it, like lawyers, but it's not really the same thing. I.e., it's harder to find someone to sign a document as a witness than in New South Wales. And I'm not sure about the other states or territories in Australia, because I haven't really lived in them for much time at all. Like I've been in Victoria for maybe a total of 2 weeks in my lifetime, as an example, if that. And anyway, so then you show evidence to that JP or Commissioner of Declarations why there's prima facie, or on the face of it, case to award you a restraining order. So you might have videos to show them where the person's threatening you, audio, or even just your words. So, on the 25th of this month, this year, that the person did get their finger and do a motion as if cutting my throat or something like that. And if the JP is satisfied, it might actually have to be a JP, not a Commissioner of Declarations, for the Peace and Good Behaviour Order, but you get the idea. If they're satisfied that there has been a threat made to assault someone or cause them bodily injury, and it can be or more than bodily injury, because grievous bodily harm is, another step above that. You also have wounding, which is less than grievous bodily harm. But, if someone threatens to kill you, they can't get out of it and say, oh, look, I didn't threaten to cause them bodily injury. I threatened to kill them, which is a lot worse, so haha, I get out of it. It doesn't work like that. But the point is, if they're satisfied that there has been a threat made to the person's self, their person, their property, or someone under their care, then they can issue a summons to attend court. You then take that bit of paper to the court, and they'll have a look at it and stamp it and set a court date. Or they could potentially do no fixed date and then inform you of a court date later. But that would be very rarely used, if ever, because of the nature of the charges. So they might say, hey, look, there's going to be a mention on the 5th of next month. And then you go to the person, you can serve the person in person by giving it to them. If they refuse to accept it, place it down before them, tell them they've been served, as I had to do with Ms. Stancombe on the 5th of September 2020, after she assaulted me the first time, and her conduct gave grounds for me to actually apply for a Peace and Good Behaviour Order. And you can also put it in their mailbox as an example. It's sort of strange because I have gotten 2 successful restraining orders in my own name and myself, and the second one, when I was at the court, they basically said it was incorrect, that the first court gave me the bit of paper to serve Ms. Stancombe, and that the police are supposed to serve the defendant, which of course makes more sense if someone's threatening to harm you and then you have to give them a bit of paper, and you don't really do process servers if you may not get your money back for that. So therefore, again, it makes sense to serve people in public if you have to do it yourself, if the police won't do it. But anyway, so then you have your mention, and then the judge, usually a magistrate, will determine, hey, look, you have until XYZ date to get your evidence in. They then have, as a defendant, 2 weeks extra or whatever it happens to be, to get their evidence in, and then say a week or 2 later you're in court. And you're supposed to then have the hearing, and usually a hearing would go for maybe half a day, if that, and then a decision gets made. But obviously if it's more complicated, or if there seem to be more than one issue, then that would be extended. So a summary is, Ms. Stancombe falsely claimed on documents intended for court, i.e. perjury, also called false accusation, but it's not conspiracy to bring false accusation, which is when 2 or more people do it, so it just gets lumped in with perjury or fraud. So she claimed on the 24th of August, which was really the 23rd of August, at a public event, that I had threatened to assault her or cause her bodily injury. The whole event was filmed by myself, and of course I did not threaten her whatsoever. She pulled up in front of me after seeing me, and then got out of a car, didn't even have time to park a car properly, and before she got out of a car I saw something in the corner of my eye, when I just had to go around some street furniture, and it looked like someone was pointing up yours. But Miss Stancombe did a video, so I see that she doesn't show herself pointing up yours in it. And then I turned around, saw who it was, because I originally thought it was probably someone stuck waiting for protesters to cross the road or something like that, for them to pull up and point up yours at some people. And it turned out to be Stancombe. So I said, hey, look, it's Anna the Defamer. Of course, I was on a live video to lots and lots of people. I think with that particular video, it might have been seen 18,000 times or 30,000 times on Facebook, plus some miscellaneous extra accounts on YouTube. But anyway, then she got out of her car, nearly broke her own door. She was illegally parked. I was waiting for the police to turn up, and also didn't know how to react to what was obviously a setup for the IMOP party, i.e. a party that has some overlapping policies with Reset Parliament Australia, which is my not yet registered political party. And anyway, so she got out saying, oh, you think you're so tough, you're tough boy, words to that effect, and then was abusing me in my face. I tried filming some evidence for the police of her being unlawfully parked, and then also obviously to identify her with the number plate and whatever. And then she goes back to her car, and then she stops her phone, and then went back to assault me, trying to barge my left shoulder to knock my phone out of my hand. She apparently has a thing for phones. She's got video on Travel to the End, which is her YouTube account, where apparently she stole some removalist person's phone, and says the president of the QLS, presumably the Queensland Law Society, told her to keep the phone. which is ridiculous. And later on you'll find that she damaged my phone as well. But anyway, not at that instance, because I was, holding my phone. I'm used to filming things and using my arm as like a gimbal or a stabilizer, but for another incident. But anyway, so she claims that I threatened to assault her or do her bodily harm at that event, which of course I did not. And then, she failed on that account. She then claimed on the 5th of September, when she was merely served with a peace and good behaviour order application, that I threatened to assault or do her bodily injury, which of course didn't happen. Again, it was at another protest, and the whole thing filmed. Anyone can look it up, and she knows that. So it's not very intelligent for events that are fully filmed for someone to make up such egregious statements. She completely failed on that account. She also claimed on the 8th of December that year, 2020, when in reality she was merely served with legal papers for defamation and breach of contract and tort of civil conspiracy action with the Queensland Supreme Court, that I again supposedly threatened to assault her or cause her bodily injury. Yet again I filmed, and lucky I did film, because she falsely claimed, including to police and others, varying her story, that I ran her over in my car, that I attempted to murder her, that I assaulted her, that I went to her house with someone else and we bashed her up, all this other stuff, which of course is all false. And it's very important when you are serving someone with legal documents to record it, especially if they're a known liar, because otherwise they just deny service. So if you do happen to get any judgments against them, then they can say, oh, I wasn't served. And some of her friends have tried something similar, where they've falsely stated that they weren't served with full copies of the claim and statement of claim in the same action. And hopefully the police investigate that soon, and those people may well hopefully be held accountable for fraud. And with that particular thing, basically they said that I didn't include 2 pages on the claim. So you have a claim and a statement of claim, and part of the claim is if you don't respond to this within 28 days, then the plaintiff may seek a default judgment against you. And I put in default judgments against 2 people in particular, so there were a number of people, but these are the 2 relevant ones. A couple who were living in Mooloolaba, and they falsely claimed through their lawyer that they were served with 1 incomplete copy, and basically with a default judgment. So if the people don't respond, they're basically admitting to it, and there's only 2 ways to basically get rid of a default judgment. One is to show that there was a really good reason why you couldn't respond in that time, so someone might be in a coma, for instance, and 2, that they have a good prima facie defence to what is claimed. So that's a rather high burden to cross, a barrier to jump over. The other way, it's automatic, and that is to claim, and obviously it should only be claimed if it's true, in which case it wasn't true in this case, but if there was an issue with service. So if the person didn't actually serve you, just say if it's a document that you must serve in person and they just shoved it in your mailbox and had it half sticking out, and a neighbour's kid went and took the bit of paper or set it on fire or something like that, or in my case, where the couple fraudulently claimed that they were only served with 1 copy, not 2 copies, and that the documents were missing these vital notices. or one vital notice in particular, but there is some other little notices around that as well, to get that reversed. And then that was used against me to fraudulently get indemnity costs awarded against me. Like I keep saying to everyone, hey, I'm good at substantive law, but not the procedural law. And with how the paperwork was set out, it was not set out in a way that the court wanted, so that got thrown out. But anyway, skipping ahead, back to the 8th of December, so Miss Stancombe was served by a friend who happened to have been Stancombe's friend on Facebook as well for some unknown long period of time. And then he went to serve her. Miss Stancombe's renowned for her CCTV camera footage where she has police going to her then property at Caboolture South. She doesn't live in Caboolture South now, but where she would publish, police going to her property, and she claims the police were harassing her, etc. And that includes CCTV footage. She had a gate there with no normal walkway, like a gate where you open a access or bridge between the public world and the private world, that kind of thing, and obviously wouldn't open the door if I knocked on it to personally serve her. And there are a number of other defendants, and they have caused me poverty as well, so obviously I can do process servers, and you wouldn't think someone would be so nutty as they are, or so vile, or so disrespectful of the law, or so violent, or whatever, as they allegedly are. But saying allegedly, she has now been found in court to have assaulted me twice, so really I don't even need to say allegedly. But anyway, so she was served by my friend, being a Facebook friend, and he happened to be visiting Queensland, and we were discussing he was interested in making a little feature film, which I have some experience in the filmmaking industry, and it was sort of a good coincidence, because I was trying to serve her with someone else the day before, and was unable to serve her. And you have to serve the person for the clock to start, because that's the way the law is. The law wants people to be served in person, because that way they can't deny that they've been served. They can't deny that they had no knowledge of the action, and that's fair enough, because otherwise someone could just say, oh yeah, I served them, and not really serve someone, and then win judgments against those people, and that of course wouldn't be fair or right. But anyway, so I was in a car and then filming, and then my friend went to her property, and then he served her. I'm leaving out lots of details, of course. And then he got back to my car, and then Miss Stancombe was screaming out that she hadn't been served because no one asked her name, even though she was known to both of us anyway. And she's publicly known too, in the so-called freedom movement. And then I, not thinking that she would do what she did, but I undid my window to make sure she can't say, oh, I didn't know I was served, I didn't know what my friend told her. I did give him instructions, if she didn't accept the paperwork, to just place it down before her and tell her, you've been served court documents, something like that. And because she chased him to the car, then I followed him to the car, whatever way you want to call it. Then I undid the window and was holding my phone between two hands like this, and said, you have been served, Anna, while she's screaming, don't you come to my effing house again. and then she unlawfully entered the car to commit multiple indictable crimes. And what she did, she smashed me in the hand, in my left hand, with my phone held between my left hand, the screen or the phone itself in between, and then my right hand. And she has stuffed up both of my wrists, which are still stuffed up, what's that, a year and a half ago. So after a year and a half, they're still stuffed up. And that includes having, proper diagnoses via MRIs and hand specialists and whatever, which I've been unable to afford to get back to. Probably need surgery in my right wrist, and I'm not sure what they can do with the left wrist. But she did that. She damaged the phone and its screen protector and a little protector over the the rear cameras, that kind of thing. And then the phone had a number of other issues with it around charging, and the camera at the back seems sort of like if someone had a loose lens in their eye where it keeps going defocused and stuff like that, and whatnot. But anyway, the point is she did that. So that's unlawful entry into a vehicle to commit indictable offences, which is 14 years maximum imprisonment. 1, to assault me, 2, to do property damage or willful damage. And then she stepped away from the car, and then as I started to drive off, she then reached into the car to try to steal, or to steal, whichever way you want to look at it, my friend's phone from his lap. Obviously, the attention on phones is presumably to get rid of evidence. So when she barged me, when was that? The 23rd of August, she was obviously trying to knock the phone out of my hand to stop the recording and make it that the phone wouldn't actually save the recording, that kind of thing. And then obviously she tried smashing my phone to do the same thing. I say obvious, but that's like my perspective of what is obvious. And then she stole my friend's phone from his lap, and then he grabbed it back, and she stuck her hand in a moving vehicle, even though I wasn't going that fast. And anyway, with that, just looking at people going by, then she claimed that I ran her over, dragged her in my car, all this other stuff. She has put in police documents where she has lied, again doing perjury, because it's documents to be used in court, that that she walked onto the road and I supposedly reversed at her, and then she had to jump up the last second onto the nature strip so she wouldn't get run over and all this other stuff. And again, it never happened, and the video evidence shows it didn't happen as well. When I passed the phone to my friend when he got in the car, he did, I don't know if he pressed record on purpose to try to start recording when I said, hey, film, or something like that, or if when he just grabbed it, he bumped it off. But there was some seconds, which I thought was only a few seconds, but it turned out it was probably more like 15 or 20 seconds of a gap between that video stopping and the next one starting. And the next one clearly shows Miss Stancombe unlawfully entering a vehicle to commit indictable offences, being those 3: assault, willful damage, and a separate unlawful entry to steal a phone or attempted stealing of the phone. And anyway, so again, getting back to the peace and good behaviour order application by her against me, that was the 3rd listed incident where she claimed that I threatened to assault her or cause her bodily injury. Again, I won that, and then she added another incident after the fact, which was on the 29th of December when I went to Roma Street Parklands at a protest to serve some more defendants in a defamation action. And then she went up to me after I served, 2 people. There's Tristan Van Rye, also known as Tricky Tritty, and before that there was Rachel Ann Wood, known as Rachel Ann, or Rachel Reiki now, as she contacted me the other day randomly. And anyway, so I served those 2 people, and then was probably 20, 30, 40 metres away, haven't measured it, and then Miss Stancombe went up to me. She lied to police, claiming that she has a restraining order against me, which I've never had a restraining order against me. And she goes up to me and then is like claiming, oh, I'm in fear for my life, blah blah blah. She's later heard telling the police when they arrived, because I called the police after I was mobbed by at least 6 individuals. Tristan Van Rye, someone, I think their name's Benjamin Thatcher, someone who I believe to be Benjamin Thatcher's boyfriend, some old looking dude that looks like Santa Claus that said he was in jail before, and a criminal I happen to know said that he does know the person. He couldn't think of his name, but apparently the person was in jail for drug related issues, like drug possession I think it was. And then there was a person who I later found out was known as Keith Brennan, and someone who's on Facebook as Zeb Cobber, but his name is Zeb Dahas. And there's some interesting people, so to speak, with, who was it? With the person I believe is Ben Thatcher, or Majin Ben on Facebook, Majin being Japanese for demon god. So the person, sees himself as a demon apparently. He said that he'll drop me on my head, or words to that effect. And of course all of this is paraphrased, and eventually, I may release video footage later. But hopefully all of these people get arrested for various crimes, such as false imprisonment, assault, etc. Then there was Keith Brennan indicated that he was going to smash my phone so I wouldn't have any evidence until I said that I was live streaming. And Zeb Dahas was going to armbar me. He also assaulted me by blowing a noxious substance, or a gas, as it is in the law, being cigarette smoke in my face. I then stubbed the cigarette out with the back of the phone, and that made him drop the cigarette on the ground. He then relit it up, again using Keith Brennan's lighter, and then blew it in my face twice more, remembering too that both of my wrists were unfortunately destroyed by Stancombe, 3 weeks before, something like that. So I couldn't really do much else, and it's unlawful anyway. So I got an ant climbing on my neck. So anyway, I called the police, and then the police went there. They believed Stancombe with her false assertions of having a restraining order against me, and the restraining order having conditions on it that I can't be anywhere near her, and I didn't even think she would be at that event, because on the 6th of December, which is 2 days before, she smashed my hands, destroyed my wrists, phone, stole a friend's phone, etc. That I went to another protest to try and serve her in public, so there'd be 15, I don't think it'd be 1,500 police, but 150 police maybe at a big protest, and she wasn't there. So anyway, then again, for her vexatious and fraudulent and perjurious peace and good behaviour order application against me, the judge again found that I did not threaten to assault or do bodily injury to her, nor is conduct that is, implying those sins, etc. Even with Stancombe, she made a big thing trying to say that I was refusing to go when the police went there, in which case, in the video, it's clear that I'm saying I'm happy to go over there, but I want you to ascertain the identities of those 6 people who have assaulted me and falsely imprisoned me, etc. And the police didn't do that, which is not very helpful. And I think there was an officer, she had some name like Schnitzel, so Officer Schnitzel or some similar sounding name, and I'm not sure of the male police officer's name. And anyway, then even the judge on the 1st of April said that I was speaking to the police in a measured way, as opposed to Ms Stancombe's claiming that I was refusing to leave the police, refusing to leave the Roma Street Parkland when the police had ordered me to go and whatever. And then he also made comment in his judgment about Ms Stancombe claiming to the police, whatever the exact wording was, go away mosquito, that, what was the wording? I don't know, her saying to the police, he's not allowed anywhere near me, I have all the paperwork with me. But it also ignores that doesn't ignore, but it wasn't taped, what she said to the police on the phone too, because apparently she called the police as soon as I went there, and then claimed falsely that I have a restraining order against me, which again, repeating for the umpteenth time, I've never had a restraining order against me. I've never done anything to warrant a restraining order against me. And anyway, so I won on all 4 different counts, even though there was originally only 3. But some of the highlights of the hearings, besides Ms Stancombe admitting to one of the accounts she uses to criminally defame me and whatnot, in which case the police are hopefully going to do something about it once I provide them with the transcripts. But she also provided evidence on the days of the hearing, and that involved her screen recording her own phone of comments on my Facebook account or whatever. So one example, I think, I'm not sure if the court actually allowed this one, but was where Miss Stancombe as William Hart and Mick Wolf profiles, she was goading me on my own Facebook business page and falsely claiming that I was charged with assaulting her and all this other stuff, which is all garbage. And then I'd do a response and put, hey, look, you were charged with assaulting me, here's a bench charge sheet, I don't have a restraining order against me, you do, here it is, issued from the court, that kind of thing. And then she either deleted her comments or just signed into another one of her accounts, where she's blocked herself as in one of her other accounts, so that those intermittent messages of her writing ridiculous things and false things was removed, so it just looks like I'm talking to myself and then just, pointing out X, Y, Z about her, in which case what I pointed out was true. And she was stupid enough to be signing to one of her troll accounts, if you want to call it that. And that particular troll account happened to have an image taken in Ilona Lan's backyard. So that was pretty interesting. After I said about, hey, look, that little icon matches William Hart's icon of 2 champagne glasses, a yellowtail champagne or sparkling wine, since it's not made in France, and the buildings in the background matches this other account. And then I found that it was in Ilona Lan, the Queensland boss of IMOT, and she's also a Australian Vaccination Risk Network, or AVN, committee member, or was. I'm not sure who the current committee members are at the moment, but done in her backyard, and at a particular seat overlooking the little canal, and you've got the mantra at some suburb or city or town in the background as an example. So it clearly identifies that the person wasn't just some random person with a stock image or whatever, in which case I did search if there were any other publicly available images that match that, and there weren't. And there's certain tools that people can use to search basically the internet for public images. And anyway, then she was signed into another one of her accounts, one in the name of her ex-boyfriend. She claimed she was married. I have reason to believe that that's incorrect, but she even claimed it in court, as in legally married. And that has a picture of a baby calf, because her ex-partner is, I believe, a Hindu, or certainly of Indian extraction. I don't know him personally, not spoken to him, despite Ms. Stancombe claiming that I have. And anyway, so she was signed into that troll account, where she has a meme saying, with the other man's image, and says something like, earns $800,000 a year, pays no child support, something like that. And that's interesting in itself, because of certain reasons, such as who actually has custody of the children, I suggest, and some other particular issues. But anyway, so she was signed into that Anil Patel account, and the URL for that is Ava Patel, which has some other significance with that name. And then she was signed into another account for another set of screen recordings, which was in her Anna Ali account, which she denied was her account to the court, which clearly it is her account. And that includes her publishing audio recordings with her and a lawyer who may or may not be Serene Tefahar, like it's got a similar type of voice, recorded at Caboolture police when she was charged with having unlawfully assaulted me. And an odd thing is, and a sad thing is, that during the hearings for the Peace and Good Behaviour Order, I think maybe on day 3, I again asserted that it was Ms. Stancombe charged with assaulting me, and Ms. Stancombe, the previous hearing, claimed that she wasn't even sure if she was charged or not, in which case that's obviously a lie. But apparently in between those two court dates, and I only found out in court because Ms. Stancombe says she wasn't charged, and I couldn't find my subpoena where I was subpoenaed to appear as a Crown witness and as victim, because I accidentally left it in the car. So I tried finding online, including looking up the Queensland criminal cases, and for some reason the case was removed, and Ms. Stancombe said that she wasn't charged, or that she might have eventually said it was withdrawn. And then I had to contact the Caboolture prosecution service during one of the breaks, and then they said basically, unfortunately, we withdrew the charge a week ago, so in between two of the hearing dates, I think it was. And oh, sorry, we didn't tell you. But anyway, so I have to pursue that perhaps through a private prosecution. And anyway, going back to the other interesting parts in the hearings, besides Ms. Stancombe then providing to the court, when signed into 3 different might even been a fourth different a Facebook account, that two of which are what you could call troll accounts or fake accounts or whatever, and then the Anna Ali one is like a normal account but just in a fake name. But the point is that, you know, she was silly enough to falsely claim that I had threatened her at events that were completely filmed, including when she was served with legal documents, and then made many lies about that, including publicly as well as, you know, to courts as perjury, etc. And then been silly enough to be signed into various troll accounts. With another troll account, she has Limgam Pro. She posted about a road rage incident that she had, where she claimed that on the 11th of March, I think it was, at about 5:15 p.m, that she confronted a person who allegedly dropped a bottle out of a window at or near the Hungry Jack's, what's that, Arundel sort of area across from Harbour Town. That apparently the person dropped a bottle out the window, so then she called him a dirty pig or something like that. I don't remember the exact words. And then he told her mind your own business, you fat cunt, something like that. But the point is that people didn't believe what she was saying, and she had images of a person and his number plate, etc. And then told people, oh, well, go to Hungry Jack's and get the security footage, which maybe someone has gone to Hungry Jack's. And anyway, with that particular, and getting the security footage, being myself. And anyway, that again proves that that particular account is hers, which Ms. Stancombe has the modus operandi or certain pattern of behaviour. What she does is, when we have upcoming court dates, she then tries to harass me and whatever, and then use that also to gather information. Like with her Mick Wolf account, she claimed about certain things, and I said, well, Miss Stancombe already said that on the current affair, that the police, you know, couldn't be bothered, this is very paraphrased, getting subpoenas for Facebook, etc. And then she was like, oh, you got a transcript. And then I used the auto transcript from YouTube, from the current affair, you know, video, and published that. And then she, the next day or 2 days later, whatever it was, said in court, oh, you've gone through and made transcripts of all my videos, making out that I'm watching her videos all day long. And, you know, obviously if you're doing transcripts from scratch, you'd have to listen probably 10 times or whatever, especially if you're not a fast typer, it might be 50 times to get the wording right, whereas it was automatically done on YouTube. But she then tried claiming, oh, that shows that Mr. Martin's a fixated person. Wonder if it's the same ant that keeps climbing on me. And anyway, just flick it away further. And that didn't work. She tried claiming unlawful stalking, and the judge said, you know, and as I pointed out, gathering evidence for getting her held accountable, either in courts, i.e. suing her, or for criminal actions like using carriage service to harass, menace or cause offence, using, you know, just doing screenshots of her public posts and whatever, is not stalking. She claimed that me serving her paperwork was unlawful stalking, in which case she's been told all along, including from the Queensland Criminal Code in the section what is not unlawful stalking, and it's got things including if you are providing information to someone that they have a genuine interest in getting, i.e. you know, serving legal paperwork. and that was for the 5th of September when she was served with the Peace and Good Behaviour Order application, as well as the actual claim and statement of claim from the Supreme Court of Queensland. And anyway, she thought she was clever, presumably, in gathering all this special information using her troll accounts and then mentioning things that only she knew about, such as service of a document that was done on me, arranged by her and some of her friends for the first day of the hearing, but then posting about it from her troll accounts as an example. Then, yeah, so she wasn't the brightest person. But now there's official judgments of the court that has found that she assaulted me not once but twice, and that all of her claims are false. The judges obviously don't say bullshit, but obviously they're bullshit, putting it nicely. And they're fraudulent and perjurous. I already said during the hearing, because Ms Stancombe was saying about, she accused me of perjury when she's the one doing perjury all the time. So again, muddying the waters. So, I was suing her in tort, including for defamation, etc., as well as some of her buddies that are associated with her, and then also got put in a Peace and Good Behaviour Order application, and then she got a fraudulent one against me, application that is, not an order, in attempt to muddy the waters. And again, she's tried that again. But anyway, again, I have to be conscious of what I say so that there isn't grounds to take down, even though it's legitimate information, but with the E-Safety Commissioner. So if I happen to say Miss Stancombe's address, her current address or something, which I know because I happened to see her after leaving court one time when she falsely claimed to the court that she was, at the time, I think 2.5 or 3.5 hours away in a government safe house in witness protection, and that she's banned from leaving the property to even get a document signed by a JP. And what else did she say about that date? That was in April 2021. And then I left the courthouse, and I was living at a place called Oxenford at the time, and the court is at Southport, and I travel on the Gold Coast Highway. So you go up over the bridge into Labrador, turn around, and basically follow that through past some suburbs like Arundel, Helensvale, Oxenford's across the freeway. And lo and behold, when I left the court, I saw Miss Stancombe with her 2 children riding bicycles. And, it's like, what the heck? So I pulled up at the next shopping centre and then tried shoving my phone on the dashboard, like wedged in a shoe or something like that, so it wouldn't fall. Unfortunately, I don't have dash cam, which would be, a good idea for me to get. And then went back and then saw her go into or children, whatever, into a certain apartment. And then turned out that that apartment's more like 10 minutes away from the courthouse, that she obviously wasn't in witness protection, that she could leave the property, that she could therefore get documents signed, that therefore she did perjury to the court. And also my PGBO application was originally supposed to be heard with actual hearing date on the 30th of April. And before the 30th of April, Ms Stancombe falsely claimed again to have a different court, I won't say what type of court or whatever, even though it probably doesn't matter, but in a federal jurisdiction, hearing date on the same day, which again turned out to be perjury. And she was supposed to provide that to both the court and to myself on a court letterhead, that she did have this conflicting date, but the matter was adjourned. And then I think it might have been, I don't know, a month or two later when the actual hearing date was. And anyway, so some of the other highlights were about Miss Stancombe, where she calls people she doesn't like, accuses them of child sexual offences, let's put it that way. And she was arguing with the judge because she apparently believed that the only evidence I could provide is in response to those specific dates, as opposed to being able to attack her credibility, where she, on many occasions, it is suggested, has falsely accused of people of being paedophiles, etc., because she doesn't like them. And for instance, she kept saying about this post from 12 years ago, where with her account that was in the name of Anna Patel at the time, and then she tried claiming, I think on a current affair, that someone made this fake account in her name, but where that references beating her children. But with that same account, I believe it was, she said to someone a message that she would say that they're into kitty and animal porn, and put that in all of her groups, that she had many different groups, such as the Caboolture Crime Watchers, that I think had 20 or 40,000 different members in it on Facebook, as an example, and some other ones that, you know, should post that about the person, and anyone that disagreed or argued or, you know, said you can't put that or whatever, should just delete them from the groups as well. And karma's a bitch, my friend, or some words to that effect. She likes talking about karma with her Sue Pool account. The URL is karma.train.984 or 986, something like that. And, you know, from various troll accounts where she's made false criminal accusations against me, she mentions karma quite often, and certain other things that, you know, just say in these 3 different accounts she'll mention this particular thing, then you've got like a Venn diagram, so then you'll have these 5 accounts that mention this one thing, so it all links sort of together. But anyway, so one piece of evidence was Miss Stancombe posting from 3 different accounts, even though only one was shown, falsely claiming that a doctor had medically raped her daughter, who is a minor, and then it turns out that what it was the doctor gave the daughter a routine medical injection, being a vaccine, as per the request of the custodian parent. And that is not private information, E-Safety Commissioner. It is publicly available information, including in judgment of the court. So again, no grounds to remove this video. But anyway, so she accused a doctor of raping her daughter for him giving her a vaccine. And obviously that's one, a bad thing to do. 2, those doctors, or that doctor and that medical clinic should go to the police, and maybe they have by now, wink wink, and maybe they even know what charges to suggest to the police that it's, you know, particular offence, e.g. using carriage service to harass, menace or cause offence, as one charge that's easy to prove. So another potential one would be section 365 of the Queensland Criminal Code, which is criminal defamation. But a problem with that is there's been so few cases about that the police don't even know it exists as a charge, let alone many other things about it. And anyway, so again, you know, I'm sure the transcripts will find their way into the hands of that medical clinic as well, and that obviously includes admission of one of the troll accounts as well, which perhaps Stancombe has used to further criminally defame and, lie and destroy someone's life, this time being a doctor, for giving a vaccine to the child. And, with the imputation that he has sexually assaulted that child, of course, which didn't happen. And anyway, so it was pretty funny in the case, her trying to argue with the judge that it is medical rape and whatnot. And what were some other particular highlights? There's some I don't want to give away because later on, if I quote the judge, and that will have more veracity and be a lot shorter video and more interesting. But that was a very interesting thing. There was also another one that wasn't used in forming of the judgment, so it wasn't in the judgment section, where Miss Stancombe complained that I had sent to a judge in a different matter that she's involved with, where Miss Stancombe declared that that judge would pay for having supposedly abused her children by awarding custody to the father. So obviously, again, with the E-Safety Commissioner, that is in a public judgment, so it is not private information, it is public information that people have the right to know. And anyway, so she was complaining to a magistrate about me sending a email, including screenshots of, it's not really a death threat, it's really a declaration of death or serious harm, because she didn't send it to the judge. She posted it on her own wall as a post declaring that the particular judge is going to pay for child abuse by giving custody to the father, which again, I don't know the father, but presumably he's not doing such egregious behaviour. So that was pretty funny. And she also complained that I sent the same judge where Miss Stancombe illegally recorded proceedings, where the judge was going to, or was considering giving a Amber Alert. Again, this is on court documents, the E-Safety Commissioner, and it's publicly available information. So you aren't allowed to record in court, obviously, even though that's a stupid thing, because why should you be forced to have to pay for transcripts? And then also there is the very rare occasion where certain things are altered, as in recordings or transcripts. But hopefully it is very, very rare, but it's publicly known that there are cases where that has happened. And then she published that, and what that entailed, which is as per public court documents, which are available to anyone that pays the money for those transcripts, is that she had kidnapped, or allegedly kidnapped, her son against court orders, and then went in hiding, in which case she claimed to the court earlier that she left her property at Caboolture since the 8th of December and hadn't been back there ever, and she was in hiding because of me, supposedly, but she kidnapped, allegedly, her son against court orders, and then she did a video with Lockie Kavanagh where the kidnapped boy is walking in the background, or allegedly kidnapped. And I don't know if she's been held accountable for that. Apparently the Australian Federal Police then tracked her down, and someone told me, I don't know if it's true or not, but supposedly they used the Lockie Kavanagh video, and then someone recognised what hotel she was apparently at, or what location, and that's how the police recovered the child. And anyway, but life goes on. And then she also complained that I sent to the judge, and it's not really sending to the judge, as I pointed out to the court, it's sending to the judge's associate, who then works out what to do with it. For the death declaration, the illegal recording, and also Stancombe keeps falsely accusing that judge of accepting bribes or taking bribes from her ex-partner's law firm. In which case, I guess I should send those screenshots to the law firm as well. So again, they can get her potentially investigated, and if the police wish to prosecute her for using carriage service to menace, harass or cause offence, because that's the sort of easiest one, unless they can show certain things like they have had less business as a result of these claims or whatever, in which case then you've got criminal defamation as an example, where the police might be bothered to actually use that charge. But anyway, so imagine arguing to a magistrate that someone is stalking you unlawfully by providing death declarations or death threats or whatever to a judge that you have stated that they're going to pay. And then Miss Stancombe in court often tried to twist what was said. So for instance, when I said about her saying on her own public post that the judge so-and-so, Margaret Cassidy, it's on transcripts anyway, so I may as well say, so where she said, Judge Margaret Cassidy, you are going to pay for what you have done to my family in this child abuse and of taking my children away, or words to that effect, that, she then is arguing with the judge that, as in my case, that is unlawfully stalking her. And then she thought she'd be clever, again apparently, who knows what she thinks in her head, but from an external perspective, where she was like, have you ever told any other judges of death threats or words to that effect? And I said, oh, well, I have actually. Justice Sofronoff of the Queensland Supreme Court, which of course I did, and that was, I don't know, probably 2 or 3 years ago now, where there was some other person that made a similar declaration that they were going to kill or harm that particular judge because they threw out their garbage court case. And anyway, so obviously all of that information can be verified as well. And again, I sent that via email, and there's records of that. Anyway, so it's been a very long video, but I'm trying to explain things and then not put other things that can get the video taken down, and that's why it's even more jumbled than normal, but just trying to explain things. So a brief summary in the last 2 minutes is I have a successful restraining order against Anna Marie Frances Stancombe, formerly of Caboolture, and that's still standing and still in force. 2, Stancombe is still trying to appeal that in a district court, which I suggest that she will again lose and have potentially massive court costs awarded against her for that, depending, if I use lawyers or if it's just disbursements with the many delays and, disbursements of things like parking fees and, travel, printing, USB sticks, etc. And she has been served multiple times for 4 cases because of false claims of not being served, that she hadn't been to her former property since 8th of December, in which case then she sticks security footage, still images from a CCTV from that property of me serving her documents into her mailbox, because after you do the initial service, which you have to do in person, this is a brief summary, then there's like applications and whatever that you can do what's called ordinary service. So that can include sticking things in someone's mailbox, etc. But anyway, so that's going on. She had a restraining order application against me, a vexatious, false, perjurious one. That was then thrown out of court, dismissed in my favour, and then she got it undismissed through perjury, and with that falsely claiming to have a different court matter at the same date, and that took precedent, blah blah blah. And then we've just had 3 days over 2 months of hearings, plus also the decision delivered on April Fool's Day, but not before midday. And she got slaughtered in court, so to speak, in that she has completely lost. It's now on record, so this is losing in the future as well. It's now on record that basically she's a liar, perjurer, but not put in those words. It's like on X date, the applicant claimed that, you know, the defendant threatened to assault or do bodily injury to the applicant on this date, but the video footage, but that is inconsistent with the evidence or the video footage. And then, as the judge said, which isn't being one-sided or anything, obviously a judge is to get to the truth, that, as he pointed out, fortunately on each of those occasions that they were filmed, and filming or videos, whatever you call it, including audio, was available. So, you know, it's brilliant. So I won. She falsely claimed on 4 different occasions that I had threatened to assault her or do her bodily injury, and I didn't do that, nor would I. And each of those charges, if you want to call it a charge, have been dismissed, and I was awarded costs. And the funny thing is, after the judge went through the 4 different things in great detail, then Stancombe hung up, and that was just after, you know, saying, and on this final occasion, blah blah blah, that is dismissed or whatever. And now it comes to costs, and it was obvious that costs were going to be awarded, which is rare in general in restraining order applications in Queensland, particularly for self-represented litigants. I did get some preliminary legal advice too, but the law firm didn't charge me for that. Otherwise it would have been $1,000 extra probably. And then yeah, so I got costs awarded in my favour, and there was a lot of expense in terms of having to serve Miss Stancombe something like 4 different times, 5 different times I guess technically, because there was also the reopening application, and I don't even know how many mentions there were. Might have been in court like 8 or 9 times, or 10 times even, and it was probably more than that actually, more like 12, because for this latest section there was, you know, 4 different dates. Well, technically there was a 5th one too, where a date was set for the final judgment to be given, so that was 5 in itself, plus there was a reopening before that, so that's 6, plus, you know, half a dozen or so before that. Anyway, you get the idea. So it's now on record, this is very, very paraphrased, but that Miss Stancombe's a liar slash perjurer, that she makes false accusations, that she assaulted me, not once but twice, that I've not assaulted her, that I've not unlawfully stalked her, and you got the whole pattern of behaviour slash conduct issue too that didn't apply, and that the judge made a finding that I'm the... Here's a little ant that kept going on me before. Hopefully it doesn't bite me. Or one of its friends. And yeah, I guess that'll do. So a victory again. I don't doubt that Ms. Stancombe might try to put in another vexatious peace and good behaviour order application, in which case she'll lose again and have costs awarded against her again, I predict. But either that or doing an appeal again, wasting my life, and I suggest her own life too. If she put her mind to something productive, with all the time she obviously has on her hands to do false accusations, it's probably been somewhere between 30 and 60 false police complaints against me by her, which again I'll be taking the transcripts to the police, and hopefully she gets charged and hopefully jailed for perjury, and all of her garbage things chucked out against me, as in I've already been arrested multiple times due to her false accusations. And yeah, happy days. Would be happier if the things never happened in the first place, but at least I've been absolutely 100% completely vindicated by the court. And obviously Miss Stancombe wasn't very happy with that, i.e. hanging up on the judge when the judge got to the matter of costs. And then so be it. So bye.